When the lawmakers make a law, they try so hard to make sure that such law is clear, but sometimes the law could be confusing and be subject to various multiple meanings. That is where the role of judiciary falls under, to interpret the law and to discover the true meaning of the legislation. And this is what the court do in every matter. To achieve justice and fairness, the court over the years have developed a process known as rules of statutory interpretation, which guides them in discovering what the law is or what the law ought to be. The first rule is the literal rule. Literal rule, just as the name implies, literal, it means apply the law as it is. Stop guessing, stop applying any meaning to it, just apply the law as it is.
Oh yes.
Example, the law says nobody should park a vehicle into this park because it's a sensitive area. On a fateful day, one particular person parked a bicycle on that very park. Applying the law literally here, which says that no person should park a vehicle here, this person, although is carrying a bicycle, has been found guilty of that very offense. The bicycle in this case cannot be deemed to be equated with motorcycles or car, which has the potential of endangering human life. But applying the law literally here means that the man is guilty, irrespective of the fact that he was using a dangerous vehicle. But vehicle remains vehicle. That is the position of the literal rule. And now we'll come to the golden rule style of interpretation, just like as I'm sitting in the golden seat. The golden rule style of interpretation simply says, please follow the law literally, apply the law straight, but if it will lead to absurdity, discard it. That is the style of golden rule. The golden rule is to refer that while interpreting the law made by the lawmaker or the legislator, the court should apply it just as we say in the literal rule. But assuming it will lead to absurdity, assuming it will lead to injustice, assuming it will miscarry justice, the court should apply the golden rule. There is an English case known as Singworth case. In that case, a son had murdered his own beloved mother in a cold blood, and the mother died without making a will. So obviously, based on that law prevailing at that particular society, the son is entitled to inherit the property based on that particular administration of the estate of the deceased. Estate means property of the deceased. The son is bound to inherit it. The court, when faced with such a situation, says there is no way you can allow somebody to reap from his own evil. Although the express provisions of that rule that governs the administration of the estate of the deceased as of that time made the child to be entitled to that property, but the court thwarted the law by applying the golden rule, so to ensure that the sacredness of the society is not discredited. Another third style of statutory interpretation, which has over the years been adopted by the court in interpreting ambiguity in our laws, are mischief style of interpretation. Mischief style of interpretation is all about purpose. When the court are faced with ambiguity, they will ask themselves, what is the purpose of this very law, and what was the law made for in the first place? This incident presented itself for interpretation in the case of Efeso and Madeira, whereby the court was faced with the interpretation of section 258 of the then 1979 Constitution, which is equivalent to our section 294 of the Constitution. By virtue of that section, the judges and the Court of Appeal and Supreme Court are meant to deliver their judgment in writing within the period of 90 days, which is equivalent to 3 months. But in this case, judgment was delivered 7 months after, and the court was faced with the interpretation of the very section. The court has to go into the historical lane to understand what was the purpose. Section 294, which was then equivalent to section 258, was for the purpose to ensure that the justice and fairness are served, because Lord Denin of blessed memory has always stated that the delay of justice amounts to denial of justice. Let's ride on. The next style of interpretation is the less cogit ad impossibilia. The law does not command the impossible. What does this mean? This means that there are situations whereby the law will look at you and will see that actually this thing they are suing you for is not something you can do on your own willpower. The law have to come in, because the law does not command impossible. Less cogit ad impossibilia. I will give you, for instance, you are a farmer and you have contracted with somebody to deliver a 50 bags of tomato, and it happens there was a heavy rain, and the heavy rain flooded all your tomato plants and nothing was left. In this case, there was already existing contract that you are meant to supply 50 bags of tomato, and in this case, you are even eating the money. What would the court do, assuming you are arrested or assuming you are sued before the court of law? The court will look at you, look at your caliber, look at everything that concerns you, and know actually if you can actually make it. In view of this whole circumstance, the court will see that actually you have lost everything and there is no way you could even be able to make up to compensate the party for the breach of contract which was occasioned by natural disaster. In this case, the court will step in and say, you are free, go home and sin no more. That is what the style of "Let's cogit ad impossibilia" is all about. The law will not command the impossible. Let's write there. Next style of interpretation is the style that is very popular. Expressio unius ex exclusio terms. If something is listed, others are excluded. What does this mean? This means that if the law expressly mentions particular things, any other thing that is not included is deemed to have been excluded. I will give you for instance, if the law says only the police are to carry firearms, and then somebody is arrested, maybe a bodyguard to a governor is arrested with a gun, or a neighborhood watch or vigilante member is arrested with firearm, that is gun and so many more. The court will be faced with this interpretation of the law as to whether it is only the police that has the right, since the law has expressly stated that it's only the police that has the firearms. Then does it mean that any other person have no right to carry firearms? If the court thinks it's necessary to follow the Expressio unius ex exclusio terms, it simply means that the court is going to hold that any other person that has not been mentioned in the constitution or in our laws does not have the legal capacity to carry a gun. That is the interpretation. Remember, all this style of interpretation is still within the discretion of the court, and the court can only exercise any of them when the statute is ambiguous or when the law is ambiguous. Ordinarily, the court is bound to apply the law as it is, the next letter, as opposed to the referenda, the law as it ought to be. But what happens when there is vacuum? That is where the court can rely on that so many of these statutory interpretation. Another beautiful style of interpretation which has been adopted by our court to ensure that justice is not defeated is the one known as utres magis valeat banquerit, which simply means the law should work and not fall. This style of interpretation is to the effect that all over the times, the interest of justice should be the paramount basis of the court. That when the court are faced with the interpretation of a particular law, they should try to pay more emphasis to ensure that the law itself is not defeated on the altar of technicalities. Criminal case that calls for the application of this interpretation arose in the case of FRN and Akane. It was a case that took place in Sokoto State, whereby the governor was exercising his prerogative right as granted in section 212 of the Constitution to grant any person concerned with crime prerogative of mercy or mercy, that is go free and sin no more. And before this very section 212, which has granted the governor the right to exercise mercy to whom he will have mercy, there is also another provision in section 36 sub 5 of the 1999 Constitution, which simply says that any person is presumed to be innocent until when proven guilty. So the question now is, can Mr. Governor exercise his prerogative right of mercy over somebody who has actually not been convicted? In other words, can you pardon somebody who is not a sinner? That was the question before the court. The court here was faced with the dicey situation as to whether the governor has the right to exercise section 212 of the Constitution in view of somebody who has not been convicted based on the word you used there, concerned with. Meaning that if you are concerned with a crime, whether convicted or not, you can actually be let go or you can actually be forgiven even when it is obvious that section 36 sub 5 say that you are still innocent. That was the question before the court. The Court of Appeal, by 3-man panel, one person dissenting, stated it unequivocally that the governor has the right, yes. Although the Constitution said that these people are still innocent, but the governor has chosen to forgive them, therefore they can go. Another case in the same state, Sokoto State, arose again in case of FRN and Ikiade. The court was called as to whether to apply the decision in Akale and FRN into this one of Dingyadi and F. And the court ruled that in order to give effect to the provisions of section 212 of the Constitution and that of section 6 sub 5 of the Constitution, this provision shall be interpreted to mean that the person must be convicted before the governor could exercise the power. Utres magis valeat quem paret was applied. The law should stand rather than be defeated. Was applied to give efficacy to this. So the court will only adapt this style of interpretation where application of otherwise will actually negate the entire provisions of the Constitution. It is not yet over. Yes, style of interpretation is not yet over. We have another style of interpretation known as Noscitur as sociis. This their word get their meaning from nearby words or from the word close to them. Let us take for instance, the law says all vehicles such as car, truck must be registered. In this case now, the word vehicle is the general word which has something like such as car, vehicle. This matter comes before the court whereby somebody is operating an airline or operating trade that is not registered. If the court tries to go with this style of interpretation, Noscitur as sociis, the court is going to interpret it to mean that all vehicles such as car, truck simply means that such a vehicle must be that which operates by road, not something like airline, not something like boat, not something like train. It must be restricted to the accompaniments of the word it gives, which is car, truck, not something beyond aeroplane which operate on another dimension, although it's still a vehicle. So this basically what style of interpretation is all about, and the purpose of all of them is to actually do justice. You will better appreciate this when you see how the court applies to it. The third thing is that you see what guides the court in making a judgment, because most often we will condemn and judge the court without knowing what is going through their head as the law, as the Almighty, when arriving at their conclusion. So know the law today. Ignorantia juris non excusat. Section 22, the criminal code. Oh, by this you could see how the court interpret our law to give it flexibility, to ensure that justice is not defeated. In this case, I stand to call on the Nigerian judiciary. I stand to call on our lawmakers to do the needful, to ensure that they put clarity on our law. And then to my fellow judiciary, which I'm part of, I encourage each and every one of us to know that we are actually a missionary of justice, and whatever we give today will stand tomorrow as a precedent to come. Let us stand true to justice, let us stand true to fairness, and give everyone according to his due. Because Oputa JLC, my beloved justice, say that justice is not a one-way traffic. It is not even a two-way traffic, but it is a three-way traffic. Justice for the deceased, whose blood is crying for vengeance. Justice for the accused, who have the right under section 36 sub 5 to be presumed innocent until when proven guilty. And then justice to the society, whose norms, whose morals have been discredited. Let no side suffer. King's advocate, the law submits. Before we go, have you subscribed to my channel? If you have not subscribed, make sure you subscribe now.